Now, you also are doing engaged in testing out the system with regard to Lozada. Is it Lozada or Lozada? It's Lozada, isn't it? Where if
Yeah.
the lawyer does potentially something wrong, or at least the next person down the line, next attorney could accuse that person to be able to reopen stuff. And that procedure to throw that attorney on the bus to be able to move things forward. What is the work? What are the work and efforts you're doing on that end?
Yeah, I'm glad you asked me about that, John, because I'm so passionate about that. It is something that from the day I stepped into immigration work, I went, what is this, right? Because it doesn't exist in any other area of law. And it's fascinating when you look at it from every level, right? Even when you have allegations of misconduct by the Supreme Court of the United States, there's no mandatory bar complaint filing requirement. It seems weird to me. Now, that doesn't mean we're not, what the coalition is doing doesn't say, if you're a bad actor, this is a free pass. That is not what we are saying. If you're a bad actor, you're going to be held accountable. But this requirement under matter of Lozada, which is the board's decision that they decided 34 years ago, when you go back and look at the history, what you find is it was designed to punish attorneys because the board did not trust them. I find that to be offensive. We all should, right? We don't really set up a system where we help clients misuse the system. That's not normally who most of us are. And yet, when the board decided Lozada, what they said is that's who we think you are. I think that should be undone. And so it's this prong of this mandatory bar complaint filing requirement that's self-contained. There's an exception in Lozada that says if you don't file a bar complaint, if not, why not? But the board has all but closed that door to where it's like the barest of exceptions that exist. And it's so at this point, if you're in certain circuits, all circuits require substantial compliance. Some circuits require strict compliance. I say, why are we doing that? The bar is there. We've all went through legal ethics. We all take ethics training. They say, look, if somebody is doing something unethical, you're duty bound to report that. We self-police. This mandatory requirement, it's just wrong. It needs to be undone.
It's not to say that people do unethical stuff. They just might miss something, or they miss a filing date. Or is that how it comes in?
Well, I mean, that's the problem, right? The board has made no distinction between human error and human unethical conduct. Well, again, there's something wrong. So if you're in the context of where does Lozada show up, it shows up generally in the context of a motion to reopen or reconsider. And that's true before USCIS. That's true before EOIR. It's true before the board. It's true before immigration court. And the problem becomes, again, is when you have that rigid a rule, then there does not leave room in most jurisdictions for human error. And I think that's a flawed system.
How do you challenge that in federal court? Do you need to get a case that has good facts or something to challenge it?
That's a tough one because 34 years of the federal courts all saying, yeah, we think this is okay because the board says it's okay. There's a couple of avenues. One, I think the attorney general, the fastest path forward is if the attorney general actually looked at it. The agencies could pass proper regulations and look at it.
Yeah.
And there were agency regulations that were proposed. They kind of died on the vine a little bit. But by the same token, even when you look back at the regulations, the agency went, yeah, we think this whole bar complaint thing is fine. I still say it's not fine because give me some justification that says it is.
Yeah.
Federal court's going to be a harder reach. I think the AG, the agency, those become easier reaches. And then really the bar as a whole, like we have to stand up and say, look, this is a problem. And we think that there should be changes made in terms of how this exception is interpreted. I mean, think about criminal defense work, right? Criminal defense counsel raise ineffective assistance or face ineffective assistance of counsel all the time. And a judge who is in the front lines of being able to weigh the law, the facts, and the process and make that determination, why can't an immigration judge do that? Why can't USCIS do that, right? Yeah. So I think though there are opportunities there for us to be able to really change the trajectory on that issue. But it's going to take all of us on every level, including our brothers and sisters in other jurisdictions, other practice areas who say, why are we punishing this one group of people?
Yeah. Yeah, I'm just thinking, what are some stuff that listeners could do to reach out? If anyone has any special thing in this, wants to get involved, definitely we'll get your contact information later to reach out about it. But it's something that's we looked into because if people make honest errors, and a lot of times people don't even make errors, but a new lawyer will come in and just accuse the person of just to reopen the case. They'll throw in the bus, even though it's unfair. Then that person has to undergo the whole issue of the bar, and until they're cleared up, it's like you get a panic attack if someone contacts you about a bar complaint. That's like a terrible thing to have to go through, and your insurance rates can go up. It's long-term consequences that affects the practitioner.
Yeah, it's an access to counsel issue. If you strip it all away, if people are not doing immigration work or they're going in a different field because they're so afraid of Lozada, it's an access to counsel issue, right? If people, and it's stressful on both sides of that equation. People who have to file the bar complaint get stressed out because sometimes it's your friends, it's your colleagues, the person just made a mistake. We're all human. We've all done that. We've all made a mistake before. And the issue here is that if people are afraid to file the complaint so they won't take the case, or they're afraid that they will get Lozada and so they don't take the case, all of a sudden, that's what you're seeing 34 years later is people are avoiding this area of law because they're like, you know what, I'll go do something else that's less stressful. Immigration's stressful anyways. And so now to pile this layer on top of it, I think it is a huge concern that, various entities, not just ALF, but the ABA, National Immigration Project, other bar associations should be standing together to say, look, this is a due process, fundamental access to counsel issue. Yeah. And, it's not just about the surface. The surface is one thing. Now, let me be very clear. People who do bad things should be held accountable, but that's true in any area of law, right? If you're a bad contract attorney or a bad criminal defense attorney or a bad probate attorney, you should be held accountable, right? But that's not what we're talking about here.
For sure. I mean, it might be in a situation where someone liked their attorney a lot and the attorney made a mistake, but they're willing to they don't want to hurt the lawyer, so they're willing to take the hit on it and just not do anything, self-deport themselves essentially. So because clients like their attorney, they're afraid to do something to somebody, they know the consequences and they'll be selfless in that way. But why put them in that position to be selfless? Why not just allow it? So there's so many angles of it. It's such a weird thing that passed. And it puts pressure on a lot of removal practitioners because that area is so complicated with criminal immigration and everything. Usually you see that issue pop up there, but also with USCIS, affirmative practice and asylum, all that kind of stuff.
Well, I mean, you know what, John, I will tell you, recently I came to, someone forwarded me a decision because I've been working on this for about a year, right? Mm-hmm. And someone sent me an I-140 denial where USCIS said, look, you didn't comply with Lozada. That's in the business practice. That's why I always say this isn't a removal or a business or a DOL. This is an immigration law practice issue, and it impacts all of us. So yeah, I mean, it's most commonly seen in removal defense, but it's not isolated to removal defense.
Wow, it's interesting stuff. So definitely we're going to see a lot of work on this field coming up, and I'll just we'll do more stuff on it in the progress so people are aware of it to protect the bar. And just as you said, it's already enough stress trying to figure this stuff out. This is like unnecessary stress that doesn't add to value to the clients. It just detracts from it.